Welcome to Practical Law's webinar dealing with misclassified employees under the FLSA, What Employers Should Do. This webinar will last for approximately 60 minutes and will be followed by a brief overview of Practical Law's resources for those who wish to remain on the line. Before we get started, there are a few administrative announcements. On the left of your webinar screen, there are two tabs. The first is the Ask a Question tab, where you can send us substantive or technical questions. We will address any technical issues immediately and will answer substantive questions towards the end of the presentation as time allows. The second is the Event Resources tab. From here, you can download the presentation slides. At this time, I would like to give a quick introduction to Practical Law. Practical Law provides practical resources to lawyers covering all major practice areas. Our resources include helpful overviews, model documents, and trend documents created by our team of expert attorney editors. We provide dedicated services to law firms and law departments. I am pleased to introduce one of our moderators for today's program, Suzanne Brown, Senior Legal Editor with Practical Law's Labor and Employment Service. Suzanne Brown joined Practical Law from Epstein, Becker & Green, PC, where she was a litigation associate in the Labor and Employment Group, concentrating on wage and hour litigation and compliance. And now I will turn it over to Suzanne.
Thank you, Saren, and thank you to everyone for joining us. We are pleased to be joined by members of the Wage and Hour Defense Institute, Jonathan Keselenko, Dan McCoy, Fred Plevin, and Paul Bittner. Jonathan Keselenko is a partner at Foley Hague and is an experienced litigator and counselor who handles all types of labor and employment matters. In the litigation arena, he has acted as lead counsel for employers in large class action cases, including wage and hour related claims brought on behalf of putative classes and claims under federal employment statutes. He also successfully represents employers in jury and bench trials involving employment claims brought in federal and state court and before administrative agencies. Dan McCoy is co-chair of the Employment Practices Group of Fenwick West. His practice emphasizes employment litigation and counseling for employers. In his litigation practice, Dan defends employers against wage and hour class actions, trade secret disputes, employee mobility disputes, claims for sexual harassment, discrimination, breach of contract, union disputes, and many other causes of action in both state and federal courts. In his counseling practice, Dan advises employers on a daily basis about employee terminations, wage and hour issues, reductions in force, employee misconduct, leaves of absence, unfair competition disputes, and many other personnel issues. Fred Plevin has specialized in serving employers throughout California for over 27 years. He defends single plaintiff and class action employment claims for private and public sector clients, provides advice regarding a wide variety of employment-related issues, and conducts management training. Mr. Plevin has an excellent record in jury trials of a wide variety of employment matters. He also has extensive experience in other employment-related claims in state and federal court, including wage and hour class actions and trade secret disputes. In addition, he has been Paul Plevin's managing partner since establishing the firm in 1998. Paul Bittner is a partner and vice chair of Ice Miller's Labor and Employment Group. He has been practicing law since 1993 with an emphasis on labor and employment law and has extensive experience representing employers. Paul is a member of the Wage and Hour Defense Institute, providing counsel to employers on all aspects of wage and hour compliance. He has tried both individual and collective actions under the Fair Labor Standards Act. Paul regularly handles a wide variety of labor and employment issues for employers, including FMLA, discrimination, and employment-related litigation. And now I will turn it over to Paul, who will serve as a moderator for today's session.
Thank you very much, Suzanne, and welcome everyone to our webinar today. And we appreciate everybody's help at Practical Law getting this together. A little bit about the program today. We're going to be talking about what happens when you have misclassified employees under the FLSA, and it could also deal with employees who are misclassified under state law as well when you're dealing with wage and hour issues, and what employers should do when that happens. But let me tell you a little bit first about the Wage and Hour Defense Institute. The Wage and Hour Defense Institute is part of Litigation Council of America. All of the attorneys who are members of the Wage and Hour Defense Institute are also fellows in the Litigation Council of America. And Wage and Hour Defense Institute attorneys are selected for membership based upon their experience and skill handling matters under both the Fair Labor Standards Act and under state wage and hour laws. We regularly have meetings. We provide information at a very high level at these meetings to discuss trends in wage and hour and Fair Labor Standards Act issues. And we also have opportunities to counsel with each other on a nationwide basis and serve as a nationwide network for our clients so that we would have experienced practitioners who also have experience in the jurisdictions where issues will arise for clients, and we can rely on each other for that type of support on a nationwide basis. So we're going to start the substantive program now, and I'll ask Jonathan to go ahead and get us started about misclassification issues. Thank you.
Thank you, Paul, and let me extend my thanks as well to Practical Law for putting this together. My name is Jonathan Keselenko. I'm at Foley Hoag in Boston, and I'm going to be kicking this off and really setting the stage for Dan and for Fred later on in the hour to talk about really the issues of how you handle a situation where somebody is misclassified. But before we get there, I just want to set the stage, as it were, and discuss sort of general principles in terms of what misclassification means and why that's important. So what does misclassification mean? Well, first of all, for those experienced in the area, you know that it's a term of art that is used in the wage and hour setting, mainly in two situations. One where an individual is misclassified as being a hourly employee. Not an hourly employee, misclassified as being a salaried employee, exempt from the overtime laws, and therefore would not get time and a half after working 40 hours, and where that is improper under, we're mainly dealing today with the federal law, the Fair Labor Standards Act, but also under the laws of most of the states of the country. The other context that it is used is similarly is where an employer has somebody that it considers to be an independent contractor, issues them a 1099, pays them in a manner other than pursuant to the federal and state laws governing employees, where that individual really should be an employee instead of a independent contractor. And we'll get into the test for what that means. So generally, for the overtime exemptions, the main exemptions are what we call the white-collar exemptions, and they're listed here on the screen. And as a general overview, there are three main exemptions in terms of white-collar: executive, administrative, and professional. Currently, the test that's used by the courts and by the Department of Labor focuses on what the primary duty of the individuals are as to whether or not they satisfy these exemptions. So real quickly, somebody is exempt under the executive exemption if in addition to some minimum wage or minimum salary requirements, mainly the primary duty must be managing the enterprise, in other words, the employer, managing the employer or its departments or subdivisions. So it is just what it sounds like. It's for an executive manager. If that's satisfied, then they're exempt generally from the overtime laws. The same goes with an administrative exemption. The primary duty must be, and this one gets complicated. A lot of people think of admins as sort of the secretaries perhaps satisfying the administrative exemption. They don't typically. Instead, the primary duty must be in the performance of work that's directly related to the management policies or general business operations of the employer. and as well there must be discretion and independent judgment that is utilized. And the third, and perhaps the one that people are most familiar with, is the professional exemption, and that the primary duty must be either in an advanced type of learning. For example, all of us on the presenters are exempt because we're lawyers, and that qualifies, but so do a host of other professions. In addition, there's a creative, artistic or creative professional exemption. The other important aspect to talk about, and I'll cover this real briefly, is that in addition to satisfying the primary duty test, it's required under the federal law that the individuals be paid on a salaried basis in order to satisfy the exemption. And what that means is that if the individual, you pay the person on a weekly rate, so that if somebody is a professional, otherwise satisfies a professional exemption, but they only work 36 hours in a week, 1 week, and so you deduct 4 hours off 40. If you do that, you'll lose the exemption. There's a bunch of exceptions to that for the Family and Medical Leave Act and whatnot, but for the most part, you need to pay attention to how you pay people because that's just as important as the duties test. In addition, there's an outside sales exemption that doesn't cover inside salespeople. It only covers outside salespeople. And there's now a computer professional exemption as well. One thing to watch out for is that this scheme could change. As some of you may have read recently, the Department of Labor announced, or President Obama actually directed the Department of Labor to take a look at the exemptions, and we're expecting that the Department of Labor will be issuing a notice of rulemaking for proposed revised exemptions in the near future. So watch out for that. This could change. It's an important issue for a host of different occupations. It's an important issue financially, as you'll hear in this presentation. It's important to remember that every employee is presumptively non-exempt. That's the presumption. So if you are audited by the Department of Labor, or if you're subject to a lawsuit, the burden will be on you as the employer to prove that there is an exemption that applies, and that applies both for the independent contractor and as well for the overtime. As I mentioned, this is an important issue. Those of us who practice in the area have seen a significant uptick in the amount of cases that have been brought, both by the Department of Labor in terms of audits and in terms of lawsuits against employers, but also as a result of private litigation. It's one of the fastest growing areas in federal courts and also in some states around the country as well. On the screen here are some of the financial consequences of misclassification issues. So it's important for you to examine your classifications, and there are a variety of ways to do that. But it's important to sort of take a look at the last time you've done this, and to make sure, for those of you who are in human resources, that it's not something that you're doing just because it was done before, but that there's actually a searching inquiry in terms of each time you classify somebody as exempt. Or this also applies, everything I'm saying here today also applies for independent contractors. So how do you go about doing it? I think Dan and Fred are going to talk about the consequences of perhaps finding that there may be problems. But how do you actually go about examining it? The first thing I want to emphasize is actually the second point here, which is the attorney-client privilege. It's important for you to at least consider in doing an examination of whether you want to involve counsel such that the inquiry would be subject to the attorney-client privilege. Generally, unless there's litigation pending, you're not doing it under the threat of litigation, so the privilege that could apply would be attorney-client privilege if, in fact, you involve attorneys. I strongly recommend that you do that. You don't know what you're going to find. If you have counsel or in-house counsel, involve them at the outset. They can structure it. The review can go through them so that the results are privileged. There's some counterbalances there in case you want to use some of the information if you think you might have a problem. That's a more complicated discussion. But again, at least talk to counsel about how to structure that. In terms of the scope of review, I think that really depends on what your view of what the problem is. If you're an employer that and I've had clients like this that have very few exemptions at the outset, and you're relatively confident, then just explore the problem ones. However, if you believe that there's been a history of classifying most people as exempt, then I think that the inquiry needs to go deeper. With regard to independent contractors, and this applies as well, the easy starting point and the starting point that you're going to get if the IRS or the Department of Labor, or this is an area where a lot of states are really focusing, is and accounting can do this for you, just take your 1099s for the past 2 years and look through the 1099s and make a determination. Some of them you're going to easily be able to weed out, such as things like the landscapers or the painters or the computer technicians that come in and fix your equipment. But take a look at the more complicated ones and make a determination as to whether you think there's an issue. Real quickly before I turn over the presentation to Fred, who I believe goes next, I want to just touch on the standard for independent contractor. In some states, the number of independent contractor cases and audits is actually dwarfing the number of exemption audits and cases out there. I happen to be in Massachusetts, which has a very strict independent contractor law, and the laws do vary by state. The law that does apply to all states under the federal scheme is the Federal or the Fair Labor Standards Act, and they use a 6-factor test. They call it, or the courts have called it, an economic realities test. And really, the baseline of that is if the individual really acts like an employee, is like all of your other employees, and these are the factors that you use to consider that, then they're an employee. If they're really acting like an independent business, then in fact they're an independent contractor. The 6th factor here really is I think, one of the more complicated and in a lot of instances the most difficult to satisfy, and that is whether the individual is a major part of the employer's business. So take a look at what the individual is doing. If you're a software company and the individual is writing your code or is somehow involved in software development, chances are you have a problem. The language that's used by the parties in the contracts, a lot of people use, or a lot of companies will have contracts with individuals that expressly state that they're independent contractors. A lot of courts will expressly not give credence to that, so they really look at the reality of what's going on. And as I mentioned, the state laws on this vary. To make things more confusing, the Internal Revenue Service actually uses a different test. Those of you who've been practicing for a while or in this area for a while may remember a 21-factor test by the IRS. They've actually distilled it down to 3 factors, which are here on the screen. So with that, I'm going to turn it over to Fred, who can go through to what to do once you have found that an employee has been misclassified. Fred?
Thank you, Jonathan. Hello, everybody. So I'm going to move forward from here. So we've done an audit. You've determined that you have some pockets of employees or perhaps some job classifications that have not been classified properly. And now the question is what to do. I put 4 options up here on the screen. And the first one is worth highlighting. I'm going to talk about each one in detail. But doing nothing sometimes is an intelligent thing to do. So you need to think about consciously doing nothing. But in making an intelligent decision, you do need to have some information so that you can go, if you're the HR person or the counsel, you can go to management and present them with some options here. And the kinds of information I think that you need are the following. Number one, is this a black and white situation or is it some shade of gray? In other words, many cases the exemption argument is not clear-cut, and you need to figure out how strong an argument you have for the employees being exempt, and you may be sure they're misclassified as exempt, or you may think that there's a legal issue there, and it might depend. How many employees are involved? I'm dealing with a client right now where they have 2 employees that they're concerned about. Well, that's going to present a different situation than if you have 25 or 30 employees and you think they're misclassified. Are these employees working, quote-unquote, overtime? Because if they're classified as exempt, you don't really keep track of the time that they're working necessarily. But if they're in a position where they routinely do not work more than 40 hours a week, or in California we also look at 8 hours per day, you have a little bit less of a concern because you're really not incurring overtime. Another question is, what kind of records do you have? Another problem people have in this area is when they figure out that someone's misclassified and they've been treating them as exempt but they're not exempt, is that by the very nature of that, they don't have time records because they're not required to keep track of time. And so sometimes you do have those records in some other form, but you want to know what kind of documentation you have regarding the number of hours that they've worked. And finally, and this was something that in one of the slides that Jonathan presented, is can you estimate potential exposure? And that's a big question. I mean, what are you dealing with in terms of the potential financial impact of this issue? And a footnote for California, if you're in California, in addition to the overtime liability, you also need to think about the other consequences of misclassification, the big ones being a potential meal and rest break exposure, and also penalties for not having all the correct information on your pay stubs. And in addition, there are some others, but those are the main ones. So doing nothing. When is this? Why could this be a good idea? Number one, and someone had put up a question, how do you avoid alerting the employee that he may have an overtime claim? Well, when you do something like misclassification, one of the big reasons employers want to be really careful about this is that you are raising an issue, and it could be a potential trigger for a claim, and that's something you always want to keep your eye on. So that's a reason to do nothing. On the other hand, if you do nothing, you're prolonging the risk to the company, because the minute you reclassify your employees, the liability starts to shrink because of the statute of limitations. So once you fix things, the liability gets smaller and smaller going forward. And it's always important to make sure that HR is fully engaged in these issues. If you're doing nothing, that they understand what's going on and what you're doing and why you're doing it. And then you may want to accrue for the risk if you don't do anything, because if you think that there is some exposure there, it's something that you at least want to alert the management to. So if you're willing to take a risk, if you have a gray area, or if you're unwilling to reclassify for some reason, sometimes it's a competitive concern. I've had cases in the software industry where the client has told me, well, everyone's classified as exempt, and if we start to treat people as hourly, we may not be able to hire folks, because in general people like being exempt. They like the freedom, and they like not punching a clock, and they like the prestige of being in an exempt position. So sometimes the company perceives a competitive disadvantage to reclassifying. And then sometimes the exposure just isn't clear. And so the company was willing to say, well, we're gonna deal with this if and when it comes up. So doing nothing is something that actually can work in certain situations. And if you do nothing, there's some things you should do to at least limit your future exposure. Number one is trying to limit the amount of quote-unquote overtime. I use quote-unquote because if you're exempt, you don't get overtime. but try to limit the amount of overtime people are working. So if they're routinely been working a lot of hours, then maybe figure out a way to get them to work less so that you're not incurring a lot of overtime liability. Self-evaluation program. This is a great idea. I've had it work really well. I've taken depositions in misclassification cases, and I'll give you another software example where the employee said, well, yeah, I'm a software engineer, but all I do is type code. They tell me to make a blue ball bounce across the screen, and I write the code to make the blue ball bounce across the screen. And so they kind of dumb down their duties when you get them in deposition. But if you took that same employee and you gave them a self-evaluation right around review time or compensation time, the employee's going to, and in my case, the same employee had said on his evaluation that he designed the architecture for the software, he designed the code, conceived of the code, and supervised others in doing it. And so sometimes if you implement a self-evaluation program, you can get employees to speak in language that says that they're exercising a high level of independent judgment and discretion in their job, and they describe it in a much different way than they do when they're litigating their misclassification claim. Also, refocusing job descriptions to emphasize exempt-type duties is helpful. Job descriptions are never dispositive on this issue, but if there's a way to emphasize the exempt aspects of the job in the job description, or that the exempt duties are the primary duties of the job, that can often be a helpful piece of evidence if you're going to be involved in a claim later on. You can exemptify job duties. So what does this mean? Well, this means you can modify the duties of the position to emphasize the performance of issues that are really more important, so that the primary duty appears to be those that are exempt, either if it's a management role or if it's a administrative role that you're talking about independent judgment and discretion in an area that's of importance to the management of the company. Sometimes if you have a personnel classification that has different levels in it, a 1 and a 2 and a 3 level, sometimes you can reallocate job duties to make sure that the 3s and the 2s are clearly exempt from what they're doing, and the 1s maybe keep them as not exempt. So you're only going to reclassify the lowest level perhaps, and then the other 2 levels you're moving job duties into so that you're emphasizing the more exempt aspects of the position. And that sometimes can work if you have a position with many different layers within it. Then you have the big issue, which is reclassifying employees, and you have a number of really difficult considerations. And I think this is very, very difficult exercise for an employer to go through. It's very challenging, but I will tell you that in my experience and in talking to employers who've gone through it, employers' worst fears are rarely realized, and a well-planned, carefully executed reclassification can be successful without triggering claims. And we're going to talk as we go forward about some of the more specific things you need to think about in order to do that. There's many things that you have to consider in doing a reclassification of employees, and up on the screen is a list of just some of the key items. And we're going to go through in the next couple of slides. We're going to go through some of them in detail. Where to draw the line? There's a tension here between cost. Exempt employees don't get overtime, and so if you have employees that are working a lot of overtime and they're exempt, that's a good thing for the employer because you're not paying them, versus the risk. If you have employees that are misclassified, that can get very expensive in the long run, because in addition to the liability for the overtime, you have attorney's fees both to your counsel and to the plaintiffs if they have a successful claim. And in California, you have other issues that can ride along with that. And so when you're drawing the line, you want to really think about what do you have in terms of what's defensible. And in doing that, you need to think about what kind of evidence you're going to have. And it's really important at this stage when you're drawing the line to think about how are you going to be able to show that these employees really do meet the test for the exemption. And think about the evidence that you're going to have. How are you going to prove it? Because it is the employer's burden to prove that. And it's easy for people to say, oh yeah, they're exempt. But the lawyer or the counselor or the HR person really needs to focus on how is it that we're going to establish that. and think about whether you have the ammunition that you need. And thinking about where to draw the line, as I mentioned earlier, many employees, I think most employees, would rather be exempt due to the prestige factor of being exempt and not having to punch a clock. And a lot of times it's perceived as a negative to the employees when you move them into an hourly non-exempt position. It's not a good thing to them. And so you want to keep your employees happy and motivated, and that's a consideration when you're drawing the line. As I mentioned earlier, in some industries, your client or the company may perceive that classifying certain workers as non-exempt puts them in a competitive disadvantage. And then in some companies, if your company has employees in different locations, different departments or different locations, you want to think about the importance of having people that are doing similar types of duties being classified similarly. So that's an important consideration as well. In terms of the timing, this is an important issue. You have to be ready. You need to have everything you need to have your ducks in a row, so to speak. You need a communication plan. You need materials. Dan's going to talk about some of the specific things that you're going to need, but it really takes a lot of time and effort to put together all the materials and plans that you need to pull this off. And so you can't do it until you're ready. Now that said, if you can do it around the time when bonuses or pay increases are provided, it sometimes works best to tie in the reclassification, which means a new comp structure to some people, with that time period when there are other expected changes happening to people's compensation. I found that that's often the most convenient time to do it. And then finally, the communication of the reclassification decision. This is a tough one. Clearly you don't want to admit liability. You don't want to tell people, oh, we had it wrong, and so we're fixing it. In most cases, it is true that the laws are vague, and we're in a gray area, and we want to err on the side of caution. We want to make sure everyone is fully rewarded. I wouldn't say compensated, but fully rewarded for any extra effort that they're putting in. And so that's another way to look at it. But this is a very sensitive area because you do not want to make an admission. And like I said, in most cases, you can truthfully provide a different explanation. And then making sure that your supervisors are on board is very important. I always do frequently asked questions. We always have a communication plan, bullet points. We roll it out to the supervisors first. In some cases, if you have key employees who you think are going to be able to get the word out and help you, sometimes it's a good thing to bring those into the fold and have them help you make sure that the right message is getting out. But the communication aspect of this is extremely important. I can't overstate that. And with that, I'm going to turn it over to Dan, who's going to take you through some more of the specifics on how to pull this off.
Great. Thanks, Fred. Thank you, everyone. And I wanted to first just echo Fred's very important theme that planning and advanced preparation before you rip the Band-Aid off here is terribly important. And Fred's already touched on that very significantly, but I want to touch on it a little bit more. So in terms of planning and planning with respect to reclassifying, the devil's in the details, as it is in most things in life, of course. With a business that already has a significant non-exempt hourly population, the implementation and the transition of folks from exempt to non-exempt is certainly going to be much easier because you will presumably already have the resources and platform in place in terms of time records and time cards, et cetera, to make that transition smoother than it could be. For other businesses that have few, in some cases, no hourly employees, they've been operating with a fully salaried exempt staff, and that's not uncommon, for example, in the technology industry with early to mid-stage startups. The transition is much harder, and companies are not aware of and sensitive to all of the minutia, the important minutia that comes with converting someone from salaried to hourly status in terms of not only just the mechanical recording of time, but of course meal and rest periods, and everything that goes with that. In terms of training, and again, I echo Fred's comment that training is critical here. It is very important to make sure that not only that the reclassified employees understand what they must do on a daily basis and a regular basis in terms of recording their hours and recording them accurately and thoughtfully and properly. It's terribly important to make sure that supervisors up front and before the Band-Aid is ripped off are aware of what they need to do from a supervisory standpoint in terms of managing the day-to-day, and of course, most importantly, perhaps managing how much overtime is being worked and whether people are missing their meal and rest breaks. So to just emphasize a basic but very important point, we're not just talking about overtime here. That's certainly the biggest part of the reclassification effort, if you will, in terms of what changes in someone's compensation. We are also talking about meal and rest breaks, and in California and every other state, essentially, employees, of course, are entitled to, non-exempt hourly employees are entitled to meal and rest periods depending upon the nature of their schedule and their scheduled workday. And so that definitely comes into play. And when you have salaried exempt employees, of course, you are not monitoring with any level of closeness, whether they are taking their meals and rest breaks and whatnot. But when you convert them to hourly status, that becomes a front and center very, very important issue that the frontline supervisors and managers are going to have to keep their eye on. So there's no one right way to train supervisors and managers in advance on this, but it is very important for them to understand that they're going to be principally responsible to manage and monitor overtime, to manage and monitor meal and rest breaks, etc. A couple of things to keep in mind on this particular slide that I think are very important. One is mobile devices. And basically everyone has one today, especially salaried exempt employees. And inevitably and invariably, those individuals who you are reclassifying from exempt to non-exempt status have been using a mobile device and have otherwise been accessing company systems remotely from home, on the road, at nights, on weekends, early in the morning, et cetera, et cetera. That's not going to change. At least the desire to do so is not going to change when you reclassify someone from exempt to non-exempt. And that's where it becomes very important to understand whether those people are checking in, again, at nights and on weekends and early in the morning. And as you all probably know, that is, in general, compensable time. There will be arguments made here and there that such access is de minimis in nature, meaning so small that it doesn't constitute compensable time. But in general, when people are accessing systems, company systems remotely and doing work remotely, that is all compensable time that could not only constitute compensable straight pay hourly time, but also overtime, depending upon how many hours they've worked. And so this is a very important issue to think about in advance, think about what kind of restrictions, hard restrictions or soft restrictions or otherwise that you're going to place on these reclassified employees in terms of whether they can access email and other systems on the weekend or otherwise outside of their normal schedule, or whether you want to be more loose about it or casual about it, if you will, but otherwise monitor that work. And if you want to be loose about it, making it very clear to the employees, if you work remotely, from your phone, from a tablet, from your home computer, whether it's a weekend or a weeknight or whatever, you've got to record your time, if it is other than de minimis time. So that's, very important to keep in mind. And then remember, in general in this context, where we're talking about whether people are working off the clock, if you will, or on the clock, the general standard in terms of whether someone can recover compensation for that kind of work is, did the employer know that the employee was working these hours, or should the employer have known? That is the basic standard. And if you have a policy as a company that says you're not authorized to work overtime without express approval in advance, and an employee who is reclassified is routinely checking in on the weekends, checking in at night and early in the morning, responding to emails, accessing company servers and the like, and the employer and specifically the supervisor is aware of this and allows it to happen, the bottom line is you're not going to be able to rely upon a policy that says that was unauthorized overtime. You're going to have to pay for that time. And that's a really important nuts and bolts day-to-day responsibility that supervisors need to be aware of in that context. Next, the other important implementation, and another important implementation issue, is the conversion of salary to hourly rates. In general, what you will see companies do here is convert a basic salary into an hourly or a commensurate hourly rate. So, for example, if someone is making $50,000 a year, they don't have any other variable compensation or unique or complicating commission plans, et cetera, they basically make $50,000 a year. That's an hourly rate of about $24 an hour for someone who works a regular full-time schedule, which amounts to 2,080 hours per year. So what most companies will do, not all, but most will do, is convert that person's $50,000 annual salary into a $24 hourly rate of pay going forward. Now that's the easy part. The hard part, of course, is when the company comes back to you and says, wait a minute, that's $24 an hour, but what happens when they work overtime? That person's going to end up making far more than $50,000 a year, and of course the answer is yes, that's the case. And so you've got really two options there. One is to, if you're looking to control the overtime and control your budget, of course, which basically everybody wants to do, is to convert them to that $24 an hour rate, but instruct them, listen, you can't work overtime unless you're expressly authorized, and the company will have to manage very carefully whether and how much overtime that person works. The other approach, which definitely has some risk with it, is to what I like to call lower the pond. And instead of converting that $50,000 a year person to $24 an hour, you convert them to $20 an hour. And you use the gap from $20 to $24 to account for the likely overtime that they're going to work. Now, of course, there are risks with that. The first risk, of course, is a morale risk with the employee in question who thinks I'm being knocked down in my pay. This is unfair, and that's a valid concern and a valid a problem for the employee to raise, of course. And many companies will not want to take that risk. What some companies will do in that context and say is, yes, we're dropping you to $20 an hour, but we're going to, given how much overtime you routinely work, you're going to make the same that you were making before as a salaried exempt employee. The potential legal risk with lowering the pond there is of retaliation. Some courts have held that where an employee has complained about their exempt status, and this reclassification occurs in connection with that, lowering the pond, in other words, converting that person to $20 an hour instead of $24, could constitute unlawful retaliation under the Fair Labor Standards Act. So it's a thorny issue, and if you are contemplating lowering the pond, as I like to say, you want to definitely consult counsel and talk about the risks associated with that under the circumstances. Next, the other thing to keep in mind beyond basic pay is benefits. What happens when you convert hourly exempt folks or salaried exempt folks to hourly rates? Will they lose any of their benefits? In general, if someone continues to be a full-time employee, notwithstanding this reclassification, in my experience, and I suspect this is true for the other speakers, that's generally not going to have any impact on health insurance coverage or those kinds of coverages. But it could have an impact on, for example, stock and other equity in the company. It's not uncommon for equity plans and company policies to provide that stock options, restricted stock, and other forms of equity grants to employees that they're limited to salaried exempt employees. And so if you convert someone to hourly non-exempt, they may no longer be eligible for that kind of equity, or it could have some adverse impact on the equity that they've already received. So that's something to contemplate as well and review in advance with counsel as to what impact, if any, that may have on an equity plan. It could also adversely impact employees with respect to their eligibility for cash bonus plans, for example, MBOs or other performance bonus schemes that are typically, not always, but typically going to be restricted to or limited to salaried exempt professionals. And when you convert them to hourly and they lose their eligibility for a bonus, again, that's going to create a morale risk for sure, and it could create some legal risk as well. So those are things to definitely keep in mind. Now, one of the $64,000 issues here, of course, is should you pay the reclassified employees for their past overtime? Fred and Paul have already spoken to this a bit. It's a difficult question, and there is no one right answer here. Of course, will this open up a can of worms, as the slide indicates at the bottom there? It may very well open up a can of worms. The answer is not specific, or I should say is not one that applies in every situation. But in general, what I tell clients is, look, you've got to ask yourself, do we have any credible defense or any credible argument that these people were properly classified beforehand as exempt, and that we are making this decision not because we are crying uncle, if you will, and admitting liability, and we clearly had no basis to treat these people as salary exempt. We're making this change because there's some potential risk there, and we want to take a low-risk approach and normalize our practices with other businesses, et cetera, et cetera. If that's the answer, and you have a credible argument that you could have legitimately classified these folks as salary exempt, then that's generally going to militate in favor of not going back to these employees and saying, we messed up, we screwed up, we misclassified you, we owe you for back overtime, how much do we owe you? And negotiate, if you will, with the employees in that context. If the answer is you were clearly wrong, you had no legitimate basis to classify, for example, a legal secretary as salaried exempt, then that's going to militate in favor of going back and at least strongly considering going back and paying the employee for that back overtime. The reason you would do that, of course, is to minimize the risk of legal claims going forward. Once you've reclassified, that does not create any sort of waiver for the employee or restriction on his or her right to sue you to recover that back overtime. And as Paul and Fred have already previewed and indicated, the reclassification necessarily creates some risk that employees will go back, scratch their head, and say, wow, was I misclassified before? What can I do about that? So, there, again, is no one right answer. It's going to be very fact-specific and facts and circumstances oriented in terms of how you approach this. But you will definitely want to consider this in advance and set up a plan of action. Either we're not going to pay anybody, regardless of whether and how many people come forward and demand repayment, or we are going to consider it, and here's how we're going to consider it. In terms of how you would calculate their back overtime, as Paul and Fred have already indicated, these folks will not have been keeping timesheets or time records in general, and so you won't have a clear, objective, verifiable record to go back to assess how much overtime is owed. What I typically will advise clients in this context, where they are prepared to go back and correct the record, if you will, and completely minimize liability, is go to the employee, have the employee estimate their overtime, have the supervisor evaluate that estimate, and hopefully come to some agreement. And then you have the employee's fingerprints, if you will, on that estimate. And so when you go back to write that check to them and get that acknowledgement from the employee that they've been paid all their back overtime, it's a very valid and forceful piece of evidence, if you will, to defend against any later claim by the employee that they didn't get paid everything that they should. That's one way to do it. It's certainly not easy, and it's not going to work in every situation. There may be other objective indicators of how much overtime someone has worked. So, for example, even with salaried exempt employees, where they are doing work, for example, under a government grant, many companies will have to report to the federal government certain hours worked by scientists and other professionals, and that's sort of an indirect time record, if you will, that you could go back and consult to see how much overtime somebody really worked over the period of several months or a couple of years or whatever it may be. If you if you pay these reclassified employees, a critical question: can you get them to sign a release in exchange for the payment? The answer is maybe. The release is tricky here because in general, and especially in California, you cannot compromise admittedly due and owing wages. What that means is if you owe someone back pay and then you pay them that back pay, you cannot then condition that payment on them signing a release of claims. If, however, in the context of a reclassification, you had a legitimate argument that these people were properly classified as salaried exempt, and that you're making this change not because you're admitting liability, but because there was a good faith dispute, if you will, about their classification, then you have a stronger basis to condition any of that kind of a back payment on a release of claims. At a minimum, even if the area here is murky, as it almost always is going to be, you absolutely can and should, in the context of paying employees back pay in this context, you can and should get an acknowledgement from them. It's not a release, but a simple written acknowledgement from the employees that they have been paid for all of their back overtime. That won't necessarily stop a lawsuit from them. They could come back and recover interest and attorney's fees and penalties for late payment and all the other things that get keyed off of and triggered off of the failure to pay overtime in a timely fashion. But if you have satisfied that back overtime obligation or liability, and you've got an acknowledgement from the employees there, that's worth its weight in gold, if you will, and more likely than not, in my experience, and I suspect Fred and Paul and Jonathan would agree, that that's going to be a very strong factor in disincentivizing, if you will, someone from wanting to bring a claim. So the acknowledgement is very important, whether or not you get a release at all. And as you can see here from the slide, it's there's no magic language, but it's a basic indication or a basic attestation rather from the employee that they've been fully compensated for this in this context for all their hours. In my experience, most companies are going to limit this type of process, back pay and acknowledgement, to overtime. They're not going to necessarily go back and say, we should have paid you for meal periods as well, so please tell us how many meals you missed, how many breaks you missed, etc. In California, for example, and this is true in other states as well, if you miss a meal period, if you're forced to work through a meal period and not allowed to take a proper lunch, depending upon your schedule, you not only need to be compensated for that time worked, you need to be compensated for an additional hour of pay for having worked through the meal period. So, that's an example of where there's additional exposure beyond the overtime. But most companies, in my experience, are not going to go and try to dig into that with the employees who have been reclassified. They're going to focus this on overtime, and in my experience, that's a reasonable way to draw the line, if you will, under the circumstances. The back pay issue is a very thorny one, and one that requires a lot of thoughtful discussion in advance with legal counsel. This is not something that you want to be addressing for the first time after you've reclassified employees, and when people are now banging on the door of HR and payroll and finance and legal and saying, what about all my back overtime? I just did some research. I talked to my brother-in-law who's a labor lawyer, and you guys owe me a bunch of back overtime. You want to be armed for that discussion and prepared for that and not be reactive. You want to definitely be proactive in this area, all things considered. So let me turn it back over to Jonathan for the summary here, and then we have a bunch of questions. I don't know that we'll be able to get to all of them, but I wanted to leave us at least 5 or 6, 7 minutes to try to go through as many of them as we can.
Actually, thank you, Dan. This is Paul Bittner, and I just wanted to conclude with our summary here. You need to proceed with care in this area. Obviously, you want to evaluate the size of the problem that you're dealing with. If you determine that there's been a misclassification, evaluate what your options are. I think that it's important to consider the do-nothing option. It sounds odd that you would consider doing nothing when you find a problem, but that's something you definitely want to evaluate in a situation like this. And then if you decide to reclassify, consider all of the issues, particularly as you've heard from the speakers, things such as the timing of the decision, what the communication process is about the decision, how the folks that are going to be handling this at the frontline level are trained to deal with it, and then what are you going to do about possible payment for the past overtime. Particularly, there was a note there earlier about the public accountability. Are you a government contractor? Are you a government employer? And what type of transparency would you need to deal with if that's in fact the case? So I want to thank Jonathan, Fred, and Dan for their presentation on the substantive areas. And now we'll go ahead and handle a few of the questions that have come in. And I can see some of those here as the moderator. One of the questions I know that we had received was, were there particular job classifications or exemptions that are more likely than others to be the, quote, target, if you will, of either plaintiffs' attorneys who are looking to bring collective or class actions under the FLSA or under state laws, or even in the Department of Labor. And Jonathan, why don't we start off with you, if you could share with the participants what your thoughts are about that.
Sure. So this is very varied, and a lot of this is actually going to depend on where you are in terms of what part of the country. But I do want to emphasize that we're not seeing certainly a limitation. It's coming from all directions. I've seen cases from very highly paid stockbrokers who are making hundreds of thousands or millions of dollars down to frontline workers. But more often than not, or I guess I should say, we're seeing a lot of cases, particularly in the area that Dan talked about in terms of the meal and rest breaks and the payment of wages. The retail industry has certainly been hit hard in this area. Restaurants have been hit with a lot of cases involving tip payment, the various tip payment laws or the tip payment requirements under the federal law. We've also been seeing in the independent contractor context a lot of cases filed on behalf of delivery drivers and in construction areas. So it's not limited. Frontline managers as well, I should add, is a common topic as to whether, in that often the issue is whether or not they're exercising control and using independent judgment in what they're doing.
Okay, thank you. Thank you. Another question we received and we wanted to address was what about the interplay between the Fair Labor Standards Act, which is a federal law that covers most all employers in the country, and particular state wage and hour laws? And Fred, why don't you take that question? What happens when an employer is facing compliance issues under both? What do they need to do? And particularly, in your experience in California.
Well, the answer to that question is the employer has to comply with the most restrictive law, and the reason states enact their own wage and hour laws is usually to do things that are more restrictive on employers than is required by the Fair Labor Standards Act. And so in California, for example, we rarely see cases brought under the Fair Labor Standards Act because California's labor code and all of its requirements and wage orders, et cetera, impose requirements on employers that are more strict. And so we're really dealing with the labor code in California, not the FLSA, although some of the concepts are the same. There are some major differences. The main one that everyone knows about being the 8-hour per day overtime premium instead of 40 hours a week, or in addition to 40 hours a week. There's one area, though, where the federal law is actually more strict in the exemptions than state law, and California employers should think about that, and that is the so-called inside sales exemption. There's a compensation test under state and federal law, but federal law additionally has the requirement that the business be a retail establishment, which is not a requirement under California law. And so if you have inside salespeople that are paid on a commission basis and you're classified them as exempt from overtime in California, and to comply with the more strict federal law, you want to make sure that you're in a retail business. Paul, one other question. I just wanted to jump in because we had 3 or 4 questions on something that I mentioned in my presentation, which is they all were on the common theme of the questions was, if you do an audit and then you do nothing, aren't you running the risk of increasing your exposure from the standard 2 years under the FLSA to 3 years for a willful violation? And the answer to that question is that really depends on whether you clearly concluded that you have misclassified the employees. Because if it's clear that you have misclassified the employees and then you choose to do nothing, that is the definition of a willful violation going forward. And so you would be increasing your exposure to that 3-year term. If, on the other hand, you think that the employees may or may not be classified correctly as exempt and there's a gray area issue, then maybe not. And I think you're in a much better place as far as that willful finding might go. Of course, in California, as a practical matter, we're dealing with a 3-year statute of limitations under the labor code anyway, plus an additional year under our unfair business practice law. So in California, you're looking at a 4-year exposure in any case.
Very good. Thank you, Fred. Another question we have here is, can an employer have a written contract with an employee to determine classification under the Fair Labor Standards Act or presumably under state law in advance and essentially contract between the employer and the employee what the status is as an exempt employee? And Dan, maybe you could comment quickly on that question.
Yeah, wouldn't that be great? That would make life a lot easier for all of us, wouldn't it? The short answer is no. That is not going to be legally controlling or dispositive in terms of an agreement between employer and employee up front about exempt or non-exempt status. And the same answer applies to independent contractor status. It is certainly relevant. I don't mean to suggest that at all. Having an agreement and understanding up front both as to exempt status and as to independent contractor status in writing is certainly relevant, but it is not legally controlling. The agencies, the courts, the plaintiffs' bar are going to look behind any such agreement to the actual duties and responsibilities that are being carried out, and those will be the things that control legally the correct classification.
Very good. Thank you. Now, one other question that we had, and we've got just a few more minutes, and we'll try to pick off a few more of these questions, but I'll just leave this out for all of the participants. There was a question or two about the statute of limitations under the Fair Labor Standards Act. We don't want to get into the nuances of any state law here, but perhaps somebody could comment on the difference between the 2-year and the 3-year statute and what's involved with that.
So this is Dan. I'll jump in real quick. So as Fred mentioned, in terms of the statute of limitations, it's where the person resides and works, what state they're in, is going to be often very important. Most states, in my experience, will back up to the FLSA and have laws that are consistent with the FLSA, but other states, including California, have, as Fred indicated, a 4-year statute of limitations when you tack on an unfair competition claim, which is almost always tacked on to such a claim. So bottom line, if you're in California, you need to assume you're going to have a 4-year statute of limitations on any type of overtime, meal and rest period breaks, et cetera, et cetera. Under the FLSA, you basically have a 2 or 3-year statute of limitations. So you're going to have no less than a 2-year look back. And if the violation is willful, you're going to have no less than a 3-year look back. We could spend the next hour talking about the case law and the developmental law around whether a violation is willful or not. Bottom line, it's almost always going to be an issue out there and something you'll want to be concerned about. So conservatively speaking, under federal law, you want to be thinking 3 years as a look back, and in a perfect or a best case scenario, you'll hopefully be able to limit the exposure to 2 years if you can establish that the violations were not willful. There's a lot of more. There's quite a bit more meat on the bone, if you will, beyond that headline answer, but that's the headline.
And one thing that gets confusing in this area is that there's also a notion of liquidated damages under the FLSA, and that comes in, there's a defense to that if the employer is acting in good faith. So it gets the two concepts get confusing, but don't lose sight of them.
All right, great, thanks. I think that's all we have time for. This concludes our formal presentation. Thanks again to our presenters, Jonathan Keselenko, Dan McCoy, Fred Plevin, and Paul Bittner from the Wage and Hour and Defense Institute, and from Practical Law, Suzanne Brown. I hope you found this session valuable. As a reminder, you can download a copy of the presentation slides under the Event Resources tab to the left of your screen. In addition, all attendees will receive a follow-up email with additional related resources that you can access through Practical Law's website. And now, for those of you who are interested in learning more about Practical Law, I'll do a quick overview of our services. Practical Law was created with the mission of helping lawyers do their jobs better, more quickly, and more cost-effectively. To that end, we provide practical legal know-how to lawyers in law firms and law departments. Our resources cover all major practice areas and include model documents, how-to guides, checklists, and more. Launched in the U.S. 5 years ago, we now have nearly 85% of the AmLaw 200 law firms and well over 2,200 companies in the U.S. as subscribers. Because there is no other service like Practical Law, we like to illustrate where we fit in. Our resources fill the gap between primary law and practical experience, effectively expanding your individual and organizational expertise. One of the things that sets us apart from every other service out there is the quality of our content. We are not an aggregator. Our resources are created by our team of over 100 lawyers in the U.S. whose full-time job it is to create and maintain our content. As you can see from the people featured here, they have significant experience, and they bring it to you. They often say that they create what they wish they had access to when they were practicing in roles similar to yours. In the many practice areas we cover, which are listed below, we are continuously growing our database of resources. Within those practice areas, our resources focus on the what, the how, and the who, all the key practical information that you need to do your job better and more efficiently. We have special practice area pages for labor and employment, litigation, employee benefits and exec comp, finance, bankruptcy, corporate and M&A, capital markets and securities, commercial, antitrust, intellectual property and technology, real estate, and international arbitration. These practice area pages give you the chance to more quickly narrow search results as well as to get a view of the most popular resources in that practice area. Our core resources in the various practice areas focus on how-to guidance found in practice notes, model documents and clauses, checklists and timelines, and toolkits that are comprised of all these types of resources and focus on a particular issue or transaction. Another thing that sets us apart is that our core resources are maintained, which means they are always up to date and reflect current law and practice. So if a statute changes or a key ruling comes down, our attorney editors quickly update relevant resources to account for that change. One important thing to note about practice notes is their ease of use. They can go from very basic to very complex. And because the table of contents on the left is fully clickable, you can skip over the information you know and immediately get to the information that you need. Our model documents are some of our most popular resources. What makes our standard clauses and documents special is the quality of the content as well as the annotations. The guidance provided in these notes, one of which is featured here, gives tips for negotiating, what both sides should be looking for, background on when and why to include a specific provision, and more. And you can easily download these for a quick first draft. Checklists are great to get a quick understanding of what is involved in a particular project, seeing the timeline for a process or activity, issue spotting, or scoping work to give to outside counsel. Some of the additional features include our What's Market database, a searchable database of recent agreements, deal documents, and filings, all of which have been summarized by our team. Compare full summaries or particular provisions across multiple transactions for an instant snapshot of market practice. Our cross-border resources provide guidance for a wide variety of issues and transactions for doing deals and conducting business internationally. As an additional benefit, subscribers and trialists also receive Practical Law, the Journal, the monthly print companion to our service. The journal is written by our editorial team in close collaboration with leading practitioners to keep you up to date on key legal issues affecting your practice. We offer 2 editions of Practical Law, the Journal, Transactions and Business, covering the latest transactional and compliance topics across major practice areas, and Litigation, covering key issues and developments in litigation practice and procedure. We believe the best way to get a full understanding of what we offer and how we can help your practice is to take the service for a test drive, which we offer for free and with no obligation. You may sign up for a trial by visiting practicallaw.com. Thanks again for your time. I hope you enjoyed the webinar. Have a great afternoon.